Okay, good morning, everyone. I'm very, very sorry for losing track of time and being so late. Okay, Perek Yud Mishna Dalet. Zehu Gufay Shal Prizbol. This is the essence of a Prizbol. Prizbol, we said yesterday, was a document by which a lender protects his debts from being canceled by Shemitah. Zehu Gufay Shal Prizbol. So now, what is the essence of a Prizbol? So the answer is the creditor states, Meiser Ani Lachem, which we will translate as I submit to you, Ish Pliny Upliny Adayanim, so-and-so judges, he would be saying their actual names, Shabamokim Pliny, that are in this and this place, Shekal Chayv Sheyeshli, that any debt that I have, She'egavenu Kozman She'eretze, that I be able to collect it whenever I want. Okay, so what's happening here is like this. There are two ways of explaining. Now, as we know, the mechanism here is that the debts are being given over to the Beis Din. It's being given over to them to collect the debts. Somehow or another, you give them custody of the debts, and they are the ones who do the collecting. And in essence, either they will do the collecting, or they do the collecting, then you can do the collecting. But once it's in the hands of Beis Din, the debt is protected from cancellation of Shemitah. So the first thing is this statement the Mishna says of Meiser Ani Lachem, I submit to you. So Rambam Maimonides in his commentary to Mishnah explains the words I submit to you as I notify you. I notify you. Rashi in the Gittin translates is I submit to you means I hand over to you the documents that attest to the debts. Okay, that is how you put the debts in their custody. You say I submit to you. Here I'm giving you these IOUs. I'm giving these documents that attest to the debts that I have on people. Now, if you learn like Rashi, so Rashi is clearly talking about a debt that's in a documented debt. That's how Rashi translates the words, I submit to you, which would sound like two things. Number one, principle only works for documented debts, and that you actually have to hand over the documents to the Beis Din, the rabbinical court. According to some, you don't have to actually hand over the documents to them. You basically, I submit to you means I am letting you know that I am halachically giving these over to you. That according to Jewish law, I am giving these over to you. They are now in your custody. We also mentioned as a question, does it only apply to documented debts? Could it even be undocumented debts? And those who learn that principle works even by an undocumented debt would say that I submit to you means I either would actually give you the documents or I figuratively give you the debts. I mean, again, I'm transferring the debts to you. So by submitting to you is the transfer of those debts to the Beis Din. So depending on how you learn what kind of debt we're talking about, that'll make a difference how to actually explain these words. Meiser Ani Lachem, I'm giving over to you. Again, the Rambam says Meiser means I'm notifying you. I'm just letting you know. That would include everything. But if it means I submit something to you, so again, we have these different interpretations. What exactly is it you're submitting? What is exactly you're giving over to Beis Din? All right. Now, it happens to be, as we will see, as we will mention again later, that actually these words of Meiser Ani Lachem, I submit to you, that the lender is saying is something that he actually declares. He first declares it to the Beis Din, and then it's written into the Prizbol document. But he says, Meiser Ani Lachem, I submit to you, and I'm submitting the debts to you. Ish Pliny Upliny Dayanim, so-and-so judges. Now, the commentaries point out very interestingly that the wording is Ish Pliny judges. That's two. So-and-so, so-and-so, and so-and-so. That's two judges. Typically, rabbinical court needs to be three. So why don't we mention two? So some learn that actually the judges necessary for Prizbol only have to be two. You don't need the three. There's no arguments, discussion going on here that you need three in order not to have a hung jury, so to speak, not to have a hung Beis Din. You don't have to have an odd number so that it's possible to have a majority decision. There's no decisions here. This person is going ahead and handing over the documents. And therefore, according to some opinions, you only need two judges. Why two, not one? I'm not sure, but you only need two. Others disagree. This is actually in the Gemara. The Gemara has an argument whether 2 is enough or no. You need 3 like any other beis din. And halachically, the Shulchan Aruch says that that a principal has to be done with 3 judges. Okay. So he says in the document, he says the names of the judges. He says where the judges are located, and then he says that any debt that I have, I should be able to collect whenever I want. Again, by submitting the debts to the beis din, that protects him, that he should be able to collect them anytime that he wants to be able to collect them, meaning even after the Shemitah. Okay, and then the Mishnah concludes, and the judges sign below, or the witnesses sign. Okay, so to explain this all, let me start reading to you here from the Ad of Ram. The formula cited in the beginning of the Mishnah, I submit to you, is the text of the oral declaration made by the creditor in front of the beis din. Like I said before, it starts up with an oral declaration by the creditor, by the lender. A document is then drawn up to attest to the proceedings. Okay, you have a document attesting to the fact that this was done. Now, there's 2 ways that this document can be formulated. You can have a document that is the statement of the judges. Okay, the text of the document may take the form of a statement by beis din, opening with the usual formula for court documents. We were seated as a unit of 3. When such and such came before us and said, I submit to you. Okay, it could the shtar principle, this document, can be a statement of the beis din that starts off with the usual formula of any court document, where the judge has said, we were seated as a unit of 3. In Aramaic, it's b'maisav tlasa kachad havena. When we sat as 1 of 3, this is when so and so came before us, and he said, Harei ani meiser, I submit to you. Which means the creditor does his oral declaration, the beis din records it as an act of the beis din, and then it's signed at the end by the judges, saying that the 3 judges sign at the bottom. That's one form of doing it. Another form of formulating this shtar principle, document of the principle, is actually that the wording is witnesses testifying to what took place. Meaning it's not the court talking. It's witnesses saying, we testify that the 3 judges were present, and so-and-so came forth and said, etc. And in that case, who's going to sign on the bottom? The witnesses, because it's a document of the witnesses testifying that this principle took place, that would have to take place, took place. The principle is a documentation of the witnesses testifying that it happened, and they're going to sign on the bottom. So there are really 2 forms of how this can be done. So when the Mishnah says about the judges sign below or the witnesses sign, it's really, there's nothing novel about that. The fact that this can be done in 2 ways is not really anything novel. It's not anything, it's elementary that this can be done this way. And therefore, the Bartanura brings down that actually it's coming to teach us a law here. It's bringing out a law that essentially there is a whole, typically when you have a court case and you need witnesses to testify, that we say a rule that a judge can't be a witness. If they're a judge, they can't act as a witness. A witness can't act as a judge. There are basically 2 separate things. The judges adjudicate, and then the witnesses testify. And you can't switch the positions. In this case, you could. Which means in this case, if the judges decided to testify, it means the judges formulated the principle not as not as them talking, not as their act, but as testifying that it took place. So they were actually the judges, but they're the witnesses also, and they're formulating the shtar principle as witnesses. That's okay. That can be done. Here we say, Dayanasa aid, that's the term. A judge can become a witness. So too, the other way around. If let's say it's not really the way around, it's the same idea. The idea is that there's no 2 separate positions that have to be here. You could actually have where the judges act as the witnesses, and the witnesses could have been the judges. The point is is that either way, right? I mean, the witnesses could be the judges in the sense that they also, one second. Right. It means in this case that the two judges that were the recipients of the debts, which is the process of how the principle works, they at the end could be the witnesses. They could record this document, again, not as their active judges, but as if they were just as if they were just witnessing what happened, even though they weren't involved. The halacha is, although they were actually involved, they were the judges, they were the ones that the principle takes place through, they could also act as witnesses. They could write up the principle in a form of testifying that it took place. And that's the point of the Gemara. The point of the Gemara is to say that you don't necessarily have to have two separate groups. You don't have to have the judges and the witnesses. It could all be, the judges could serve as witnesses also. Now, the Adarabam brings down a number of interesting halachas here. And that is that there's a big discussion that starts from the Gemara as to what kind of Beis Din we're talking about. Basically, how important a Beis Din do we have to have? At the end of the day, the halacha is you have three, witnesses, three people. You could just have three adult men coming together, and that can be your Beis Din to go ahead and perform a principle. And the Shulchan Aruch brings down a principle doesn't have to be written. You could just make an oral declaration in front of the Beis Din. Even if it wasn't written, it can work. And actually, the Ramah also, the Shulchan Aruch brings down that if a court is far away from the location in which the document is drawn up, one may declare in front of witnesses that he gives his debts over to the judges in such and such town, which means that you don't have to actually be there. Okay, again, Ramah rules that if the court is far away from the location in which the document is drawn up, declare in front of witnesses that he gives his debts over to the judge of such town. Meaning you don't have to actually be in front of the judges. If you say in front of witnesses, you're giving over the debts to the judges over there in that town, that also works. So they need to be aware of it. I'm sure that it's going to happen, but it doesn't actually have to be in real time. It doesn't have to actually be that the person is standing in front of the judges and saying it. If he tells witnesses that he's giving over the debts to the judges in this place, that also works. That would also be a kosher principle. Okay. Sefer HaMitzvot now. Okay. Mitzvahs lo yisaseh, a prohibition, not to withhold three things from one's wife. And the words of the Torah for them are she'er, kasus, va'ina. And we'll soon explain what those things are. Shenemar, as the pasuk states, she'era ksusa v'nasa lo yigra. He cannot diminish her she'era, her she'er, her ksus, her oina. This is actually talking about that if a person, about the mitzvah that if a girl is sold as a maidservant to someone, that it's a mitzvah that either the master or master should marry her. The Torah says that when he does marry her in this kind of situation, he has to treat her like any other wife. And it says, do not diminish from her, don't take away from her, she'er, her ksus, her oina, which just doesn't apply to that case, it applies in all cases. These are three obligations a man has to his wife, which there's a prohibition if he holds them back. So what are these three things? She'era, the word she'era, elam azaynis. It means feeding her. Husband's obligated, Torah obligates a man to feed his wife. Ksusa, mashmai. The word ksus means clothing. He has to clothe her. Aynasa, literally, ana means her time. Tashme shemita. It means conjugal intimacy. He has an obligation to give that to her. And one who willingly holds back these three things from his wife, to cause her distress, to cause her suffering, he transgresses this prohibition. The rabbis of the Mishna, the Talmud, they obligated a man in 7 more things. So again, the first 3 things are food, clothing, conjugal intimacy. These things, if he willingly holds them back from her, that is something he transgresses prohibition. Now, the sages obligated him in 7 more things. These are they. Iker ksubasa, the principal ksuba. When a man gets married, he writes a ksuba, a marriage document, and there are certain monies that he is obligated to give her as her ksuba. So he's obligated to do that. The principal ksuba, because in a ksuba there are extra things that are added into it, but there's a primary ksuba. There's a certain amount that the Torah obligates a man has to write for his wife in the marriage contract that were he to divorce her or to die, this amount of money automatically goes to her. So he's obligated in the principal amount of the ksuba, which is again rabbinic. I'm saying the Torah. It's a rabbinic obligation, and the rabbi said a certain amount that he had, that principal ksuba that is an obligation that everyone has to go ahead and promise their wives. The Rapaisa, if she gets sick, he'll heal her, and he'll make sure that she gets well. Spend his money to get her well. Lifdaisa, if she were taken captive, to free her. Ulakavra, if she dies, to bury her. These are all his obligations, his responsibility. And she can live in his house, on his property, as long as she's a widow and she is fed, she is sustained from his property. Basically, as long as she remains a widow, she will continue, she has the right to continue being supported from his estate. And her daughters are again also supported from his properties after his death until they get married. Once they get married, no more obligation. Until they get married, his estate is obligated to support them. And the last thing is called the ksuba of her male sons. This is also part of the ksuba, but it's very specific. Basically, it's talking about a situation where she's married to this person. He has sons from a different marriage, and now he marries her, and they have sons. So at a certain point of time, when he dies, they split up his estate. I mean, they're all his sons. They're all sons from the same father. They are going to split up his estate when he dies. Ksubas Benedichrin means that part of the ksuba says that were she to die before him, which means she didn't get her ksuba, she didn't get it. When he dies, the principal amount of the ksuba she was supposed to get, her sons get, and only after that is everything else divided up. There's a guarantee that what she was supposed to get from her ksuba goes to her children after his death. When his estate is divided up, there's the amount of what she should have gotten for her ksuba were he have to have died in her lifetime. That amount first has to be given to her sons. After that, everybody's going to go ahead and divide up the rest of the estate equally. Now, now after the rabbis gave obligations upon him, they actually gave him certain rights over her because of that. And that is because he has an obligation to support her. Therefore, whatever her maisida means, whatever she produces, whatever basically monies or things that she produces from the work of her hands, from her work, goes to him. If she owns property, so the fruits of the property, or whatever is made off of the property, whatever profits come from the property, during her lifetime, so again, because he has an obligation to redeem her, the sages said that if she brings a property into the marriage, so it's her property, whatever produce or profit is made off this property during her lifetime goes to him. And he acquires things that she finds, Mishum Eva, so as not to cause hatred between the husband and wife. The Yarsha, and were she to die, he inherits her properties that she brought into that belong to her, because of the fact he's obligated to bury her. Because of the obligations that the rabbis instituted that husband has to the wife, they basically gave him certain rights over her monies. A man is obligated to support his children, his sons and daughters that are minors. This applies in all places and at all times. And I apologize for being so late. Have a wonderful day.